Supersonics Money Transfer is giving you an unbeatable offer this Tobaski. Your family and friends can now send you monies from the whole of Europe, US, Canada, and Switzerland for absolutely free. Yes! This Tobaski, enjoy our safe, fast, reliable, and convenient money transfer service with the largest payout network in the Gambia at zero transfer charges. So your family and friends wouldn't have to worry about transfer charges when sending you monies from Europe, USA, Canada, and Switzerland this Tobaski. Visit the Google Play Store or the Apple Store today to download the Supersonics Money Transfer app and enjoy excellent money transfer services only with Supersonics. Support your own. Tobaski just got better with Supersonics Money Transfer.
Today was appointed for the second reading in accordance with Standing Order 66-2. I therefore, in pursuance to Clause 67 of the Standing Order, I now invite the Honorable Attorney General and Minister of Justice to move a motion for the second reading of the bill entitled to Civil Marriage Amendment Bill 2020. Honorable Minister of Justice.
Thank you very much, Honorable Speaker. Honorable Speaker, I wish to move that the bill entitled Civil Marriages Amendment Bill 2020 be read the second time. Honorable Speaker, the object and reasons, as we alluded to earlier, these are a series of amendments and repealings that we are doing pursuant to a study that was carried out across the laws of the Gambia with the intention of rooting out all provisions in our laws that are discriminatory to the rights of women and girls. The Civil Marriages Amendment Bill of 2020 seeks to repeal Section 8 of the Civil Marriages Act. And I believe with little bit of contextual explanation, it will save a lot of debate time, because when members understand the context, probably the contributions will be directed and probably be very brief. Section 8 deals with consent to marriage of unmarried minors. It is acceptable, and it is part of our laws now, be it the Women's Act 2010, be it the Children's Act of 2005, and most recent legislations in this jurisdiction, that marriage is meant for adults. Children below the age of 18 are not supposed to get married. They are supposed to be in school. So even whereas they get married, they cannot give consent to that marriage by virtue of their age, because they are considered as minors. So in the Civil Marriages Act, Section 8, it says the father, if living, of any party to an intended marriage under 18 years of age, the party not being a widower or widow, or if the father is dead or unable for any reason to give such consent, the mother of the party, or if both parents are dead, unable for any reason to give consent, then the guardian or guardians of the party, if any, will have authority to give consent to the intended marriage, and the consent is hereby required for the marriage of the party unless there is no person authorized to give the consent. Under our 1997 Constitution, consent to marriage has to be the consent of the two intending parties, not anybody else. That is the provision of the Constitution. So to repeal this is to bring in line this provision with the Constitution. So that Section 8 is being proposed to be repealed. And finally, this bill seeks to amend Section 16 by adding a new paragraph. Section 16 deals with marriage when invalid, and you have given situations where marriages can be deemed to be invalid. A marriage celebrated before the registrar shall not be valid unless the parties thereto have obtained certificate of registrar or license of the president. If there exists any impediment of continuity or infirmity, among others, and C, if celebrated under a false name or false names, D, unless celebrated in the presence of at least two witnesses, and E, if celebrated between persons either of whom is already married. These are the grounds that invalidates a marriage. We're talking about civil marriage here, the marriages that takes place at the Ministry of Justice. Now we are adding another paragraph. That is this F we are proposing in the bill. In addition to this list I have read, if celebrated between persons either of whom is below the age of 18, will also be a ground to invalidate the marriage. This is bringing it in line with the earlier amendment. That is, we don't take children to get them married officially before the law, because these are official marriages sanctioned by officials of the government. Okay, I understand the personal law issues that will come up, people will raise. Those are taken care of under the Children's Act and other laws where they have been subjected to personal law and others. I don't want to go, but this is a marriage that is celebrated at the Ministry of Justice, which means the law is officiating the marriage. And we cannot officiate something that is unconstitutional. So this changes precisely is bringing these provisions in line with the Constitution, that any marriage involving a party that is below the age of 18 is invalid if the marriage is celebrated at the Registrar General's office. And also, there is no need for any adult to give consent for the marriage of a minor, because minors are not supposed to get married, at least officially, before us at the Ministry of Justice. I move on those terms. Honorable Speaker, thank you very much.
Thank you, Honorable Minister. Any seconder? Combo East.
Thank you, Honorable Speaker. I rise to second the motion.
Thank you. Thank you. In accordance with clause 67(1) of the standing order, I will now open the floor for the debate on the general merit and principle of the bill. Any honorable member who wants to take part in the debate may do so by raising your constituency tag. Khalifa. Honorable member for Serakunda.
Thank you very much, Honorable Speaker. Honorable Speaker, the purpose of the bill, which constitute the objects and reasons, is already very clear. The Constitution of the Republic is the supreme law of the land. And Section 4 of the Constitution asserts the supremacy of the Constitution. So all laws must be brought into conformity with the Constitution. Otherwise, those laws must become null and void. So what is very clear is that the marriage that we call civil marriages is marriage that is registered by the state. So this state is the custodian of the law, must enforce the law. And the branch of the state, the executive, must speak the language of the Constitution. And that language is also the language of the courts. So what is being done now is to ensure that this state, which is responsible for registering marriages, should not register a marriage of a minor, somebody that is under 18. Honorable Speaker, the language is very clear, and I don't think I would stand here and oppose such a bill. And rather, I will support wholeheartedly that this bill becomes law. Thank you.
Thank you. Honorable Member for Serekunda. I now call on Honorable Member for Brikama North.
Thank you very much, Mr. Speaker. The objects and reasons added to by the Justice Minister quietly explain the rationale behind the bill, that is simply to harmonize the Parent Act with the Constitution. Even whereas this act is in place, the Constitution will always prevail, and therefore there is a need for this move to harmonize the act with the Constitution that required repealing Section 18 and furthermore, Section 8 rather, and furthermore, to add this Section 16, an additional clause where the issue of the consent of the parent is addressed, and the issue of minors also are addressed. I think with that, the bill is not a bill that could be controversial, and therefore I join my colleague to highly welcome the move to put this bill before the consideration and adoption of the Assembly, and I put my support, Mr. Speaker.
Thank you. Honorable Member for Woodley East.
Thank you. Thank you very much, Honorable Speaker. I also believe that this is not a controversial bill, and it appears just a simple ceremony. Those who really want simple ceremony without any interference from any sector can easily go for civil marriage. My understanding is that civil marriages are not necessarily conducted under religious denomination. That's my understanding. But rather by the state, like the Attorney General's chambers. And the objective is to have it in record that these people have married at this stage. Their ages will be known as well, and they'll be recognized by the state. So that at the end of the day, whatever happens, they can always go and settle it at those levels. Honorable Speaker, couples, there are many couples now, people who would want to get married, but say their parents may not be in line with the marriage, will refuse, and they really want to get married. So there are other people in society who could witness them. This is an option for some of those people because they will try the traditional method, and because of the difficulties in the culture, they'll find it difficult. But with this one, you have an option to go to the Attorney General's chambers and register your marriage there. Also, Honorable Speaker, I think this amendment seeks to ensure that no one is married who is below 18 years. And the other objective, as I said, is to meet the legal requirements of the state. You will meet that. So, like the others, to meet our protocols, international protocols like CEDAW and African human rights, those are the objectives of bringing this bill, so I support it. Thank you.
Support this amendment, and to also inform the committee that this was part of the bills that were committed to the Select Committee on Women, and we had done extensive consultation with stakeholders. Just to inform members that the consultations with the stakeholders on this particular amendment was really supported by the stakeholders, that it is progressive, marriage is consent, and someone who is under 18 years cannot consent on matrimonial ties, and that this is in accordance with the Constitution of the Republic, Second Republic, the conventions that the Gambia had ratified, the CEDAW, the Children's Act. So it is really in line with the law and international best practice. Someone was saying better practice, but whichever way, but as a standard. And then I think everybody would be convinced that someone who is under 18 years is not liable for offenses that one commits. It's only after 18 years that you are liable for offenses, basically, generally. So as such, marriage should really be based on the adult. As the saying goes, it's not a child's play. So it's only adults who should consent to matrimonial ties. So I want to register my support, and to repeat again that the consultations with stakeholders, they all supported this amendment. I'm sure we're going to do the same. We're going to re-engage them again. But just to inform you that that had been established. So thank you very much, Mr. Speaker.
Simply because I am totally against children getting married before the age of 18, because it is against the Constitution of the Gambia, and most of the time it is not to their consent that they get to those marriages. Sometimes it is because of force. So we have to support everything that is against the Constitution of the Gambia. But we have a problem in the Gambia. The Maslaha syndrome is too much in the Gambia. Sometimes, and the enforcement too of these laws is a problem. Sometimes we have problems of people getting married before 18, and nothing is done about it. And it's the order of the day now. People are getting married before the age of 18. And people sometimes know, even within ourselves here, sometimes we even see those things in our communities, that people below 18, 16, 15 years are getting married, but we are always silent about it. We don't report to the necessary officials to take actions or to take steps on these matters or issues. So I'm appealing to the government to make sure that there is real enforcement. Thank you, Honorable Speaker.
Of Justice to respond to the issues raised and wind up the debate. Honorable Justice Minister.
Thank you very much, Honorable Speaker. I can only thank you for supporting the bill. It's like it's unanimous. All the speakers supported it, and we take note of the last speaker's position of issue of enforcement. We will take note of that. But there are not much issues raised that will require a specific response. I thank members for supporting the bill at this stage. Thank you very much.
And seconded that the bill entitled to Civil Marriage Amendment Bill 2020 be read second time. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it. the Civil Marriages Amendment Bill 2020, deemed to be read the second time. Thank you. Honorable members, in accordance with clause 68(1) in bracket of the standing order, the Civil Marriage Amendment Bill 2020 is hereby referred to the Assembly Business Committee for committal to either the committees or the Committee of the Whole House. I thank you all. Bill, second reading of the Christian Marriages Amendment Bill 2020 by the Honorable Attorney General and Minister for Justice. Honorable members will recall that the first reading of the Christian Marriage Amendment Bill 2020 was done on Monday, the 22nd June 2020. Today is the appointed date for the second reading in accordance with Standing Order 66(2) in bracket. Therefore, in pursuant to Clause 67 of the Standing Order, I now invite the Honorable Attorney General and Minister of Justice to move a motion for the second reading of the bill entitled Christian Marriage Amendment Bill 2020. Honorable Minister of Justice.
Thank you very much, Honorable Speaker. Honorable Speaker, I wish to move that the bill entitled Christian Marriages Amendment Bill 2020 be read the second time. In addition to the objects and reasons stated at the back of the bill, which is general in nature, I wish to specifically inform this Assembly that the Christian Marriages Act that we seek to amend, which is Cap 4105 of the laws of the Gambia, Section 10 is being proposed to be repealed and replaced by a new paragraph. Section 10 deals with when lancings not to be granted. There is a situation where a lancings evidencing the marriage could be refused. In that paragraph, in the old, in the Principal Act, it states for avoidance of fraud and collusion in obtaining of licenses for marriage, before any license is granted, one of the parties shall personally swear before the President that he or she believes that there is no impediment of kindred or alliance or any other lawful cause when either of the parties, not being a widower or widow under the age of 18 years, that the consent of the person or persons whose consent to the marriage is required under the provisions of this Act is obtained, provided that if there is no such person or person having authority to give the consent, then an oath being made to that effect by the party requiring the lancing, it shall be lawful to grant the lancing, notwithstanding the want of such consent. Now, embedded in that paragraph, there is still a requirement for somebody to give consent to where one of the party is below the age of 18. And this is what we are trying to eliminate in the Civil Marriages Act. So equivalently, we are eliminating it from the Civil Marriages Act as well. So the new paragraph reads as follows. A marriage license shall not be issued unless one of the parties personally swear before the President that he or she believes that there is no impediment of kindred, alliance, or of any other lawful cause, or that neither of the parties is under the age of 18 years. Simple. The other one has provision that if one of the parties is under 18, the person must satisfy that a consent was given. But we are saying we are getting out of that arrangement completely. So we are now replacing that paragraph by saying you must confirm that there is no kindred alliance or any lawful cause, but then there is also none of the parties to the marriage is a minor. You must confirm that before a license is granted to you under the Christian Marriages Act. The second proposed amendment is just the repealing of Section 11 and 12. Section 11 is entitled Consent of Father or Guardian Necessary in Cases of Marriage of Minors. Remember, this is what we are removing. That's what we remove in the civil marriages. So no issue about minors, so we are deleting it. Section 12 is entitled, the Chief Justice in certain cases may authorize the marriage of parties. No, it's unconstitutional. Marriage is always on the consent of the two parties. So we say that that section also be deleted. These are the two proposed amendments. I believe it will equally be considered as non-controversial. We move on those terms and seek your support and approval. Thank you very much.
Thank you, Honorable Minister. Any seconder to the motion? Upper Flood West.
Thank you, Mr. Speaker. I rise to second the motion, and if I may, I just want to ask for clarification from the Minister. What's the difference between civil marriage and Christian marriage? In the sense that, for a civil marriage, the concerned parties have to, the Registrar General has to be satisfied with such issues as like the provisions these clauses are trying to address. But in the case of the Christian marriage, they have to personally go to the length of going to the President to affirm that there is no impediment or any unlawful cause. So can you help us clarify that, please?
67(1) in bracket of the standing order. I will now open the floor for the debate on general merits and principles of the bill. Any honorable member who wishes to take part in the debate may do so by raising your constituency card. Woodley East.
Thank you very much, Honorable Speaker. Honorable Speaker, some of these acts have come into being a very long time. So it is my expectation that possibly there are many areas that will require amendment to conform with present times, CEDAW, African Charter, etc., etc. Honorable Speaker, there are three things that I mentioned there. One is age. One is parties to swear before the President, and whether there is any impediment of kindred or alliance. Honorable Speaker, I came across a survey conducted by OECD Development Center, which they have done in 2019, regarding discrimination in the family, the percentage of girls under 18 that are married, and it's quite revealing because it's saying 25% of girls that are married in the Gambia below the age of 18. And this effort that we are doing to discourage that practice should continue. So, Honorable Speaker, when it comes to parties to swear before the President, I was wondering, which President? I was saying maybe there is a President within the church system that they should swear, because on the Christian marriage, from the people I've spoken to, is either the priest or they have their or a sister or something, Baptist, etc., etc., who would consent or who would witness the marriage. But I don't know this President that you are talking about. What does that President mean? Honorable Speaker, I'm also informed that marriage vows are not even universal within the Christian denomination, especially when they are doing these marriages. They are not doing it in the same way. So I was thinking that maybe there'll be a need for the committee, whichever committee is to take over this, to consult the different denominations in the country to ensure that we are not infringing on their methods of solemnizing marriages in the church. When it comes to the impediment or alliance, Honorable Speaker, I think there are several ways that we can determine to prove a person's freedom of marriage, freedom to marry. Because like I said, you have baptical certificate, I am told, a letter of freedom from a parish, a parent or a relative or close person to write a letter to the person that the person has never got married. Also, a person to swear an affidavit. These are all means, I am told, that you can conduct a Christian marriage, or even affidavit before a commissioner of courts to attest freedom. So priests can also witness marriages in the church. So as I said, this will require a lot of consultation with the different denominations. But in principle, I am in support. I think it will go a long way to discouraging marriages below the age of 18. Thank you.
Honorable Speaker, it is very clear that marriage is already based on a right, and right is already well defined under Section 27 of the Constitution. Men and women of full age and capacity have the right to marry and found a family. That is the foundation. And every other act must be brought into conformity with that. And what we are being told is that the age of 18 matters very much now as the age that is conceived to be full age. And therefore, in order to bring the Christian Marriages Amendment Act into conformity with the concept of full age before consent, then the amendment is well placed. But Honorable Speaker, I concur with the member for Woodley East that there are individual rights, but there are also group rights. And the Constitution recognizes group rights. That is why it provides for freedom to belong to a faith. And in belonging to a faith or belonging to an association, you are being given the opportunity to extend that individual right into a group right. So in that respect, the Act is talking about Christian marriages. And any attempt to amend this Act should be done in actual consultation with the group, knowing fully well that the issue of age is universal as far as it is conceived in the Gambia. But notwithstanding, other elements are there which may ultimately require to be looked into again, and one may gather from those who are custodian of the faith their views on acts that have been with us since 1862. So we are not talking about acts that came yesterday. They came even when the colonialists were trying to take over our homeland and turn it into a colony, and had succeeded only in getting pockets like Banjul and Kombo St. Mary. So in that sense, I concur that whilst I fully support the spirit of ensuring that we bring all laws, including this one, into conformity with the Constitution and the standards of best practice all over the world, we must involve the people so that, in fact, we will be able to achieve more. Thank you very much.
The two bills that we have before us here today, this morning, are very important because they are simply talking about early marriage. They are discouraging early marriage. Honorable Speaker, early marriage deprives this nation from having so many doctors, medical doctors, nurses, engineers, teachers, and so many professions, simply because most of the girls who get married before 18 have so many ambitions to be professionals in different fields. But because of early marriage, they were not able to achieve their aims and ambitions, their long-term plans. So coming up with this bill, it will really help the nation to have so many experts to be able to develop at a very fast rate. So I'm still, as I did before, appealing to the government to make sure that there is real enforcement. There should be real enforcement. This even sometimes traumatizes children. Imagine you've been forced to be with a man that you don't love or that you don't intend to get married to for so many years. You have so many kids. Sometimes it's even pushed them to be rebellious in their houses. Yes, some can even go to the extent of doing things that can even lead them to be in jail. Some even poison their husbands. Some even stab their husbands because of the pain that they went through, that they go through every day, every night. So it's very unfair. So coming up with these amendments will really help this nation at large. Thank you very much.
Thank you.
1862, the move itself is a necessity in the sense that the act is a colonial law, and there is a need to review those kind of laws so that they can be in line with the current realities. I believe it is in this spirit the bill seeks to address as the current realities imply that the right of the minors should be respected and guaranteed before the law in terms of marriages. This is what this bill seeks to address. Since in section 10, which is supposed to be repealed and replaced, there is still the requirement for one to give consent for an underage. Likewise, section 11 and 12, inasmuch as I am in support of the move, equally I'm concerned as what is the position of the faith in this issue, which I would like the Honorable Minister to shed light on. Thank you.
Thank you, Honorable Member. May I now call on Honorable Member for Banjul North. The floor is yours. Banjul North.
Thank you very much, Honorable Speaker. Honorable Speaker, I also wish to inform this committee that this was also committed to our committee, and we did the necessary consultation with stakeholders. Of course, what was missing was engaging the representatives of the Christian Christian missions and churches. Whilst we were on the verge of inviting them, that was the time that the Attorney General and Minister of Justice withdrew that bill. So we could not proceed with the consultation on the issue. But with those that we have engaged, in fact, some belong to the Christian denomination, but all the stakeholders agreed with the amendments. The only point at issue, the bone of contention, was the president. They cannot see where the president can be involved in matrimony. So all the stakeholders, that was their issue. So they would want to see that expunged and replaced. And of course, the replacement had to do with the views of those that are representing the Christian denomination, like the Gambia Christian Council. They are the principal stakeholders. So they need to be on board, to be consulted. But that is the point of bone of contention. The president. Why the president? So I just wish to inform the committee that this is what the Committee on Women have done. And of course, we also share the position. In fact, all that I'm saying is that the committee concluded and agreed with the positions as presented by the stakeholders. So thank you very much.
Of Justice to respond to the issues raised and wind up the debate. Honorable Minister.
Thank you very much, Honorable Speaker. The member for Upper Florida West want to find out the difference between civil marriages and Christian marriages. I think the fundamental difference is the way the marriages are solemnized. The civil marriage is solemnized by the Registrar General and is administered under the Civil Marriages Act, the legislation governing that type of marriage. The Christian marriages are solemnized in a religious way. The civil marriages doesn't involve any religious ceremony. And it's the parties don't have to belong to any particular religious denomination. Whereas the Christian Marriages Act, or Christian marriages in general, is meant for Christians and is administered according to their religious standards. It's administered by a minister, usually in a church, and it follows all those religious requirements. That is a fundamental difference, and the two legislations are different. And for me, basically, this is what I see as the major difference. The way the marriage are solemnized, which determines who are going to be the parties, and it determines the relationship and how they're going to get divorced and so on. So that is it. But there are times where Christian marriages equally have to come to court when they have to separate, just like civil marriages and so on. Then, so the one is religious, one is non-religious. We also have Muslim Marriages Act, meant for Muslims and to be governed according to the Islamic way. The issue of precedent raised by Willie East Banjul North is the president, yes, is the president of the Republic. You wanted to find out which president. But the powers of the president are delegated to the Registrar General at the Ministry of Justice. So if there is any requirement for you to make a declaration before the president, you make that declaration before the registrar. So the name or the title president is there, but everything is done at the level of the registrar. With that understanding, I know those are very old provisions. I heard Banjul not saying some of the people that were part of the consultation have questioned why president. I don't think I can answer the question why, but I can provide the legal provision that the power of the president by Order 30 of 1942 have been delegated to the Registrar General. So they don't necessarily have to send any document to the President or make any declaration before the President as a person. So just like civil marriages are solemnized before the Registrar, if an issue arises, usually the President's involvement in these Christian marriages are where lancings of marriages are to be issued without publication of bans in churches. You know, in that situation, such declaration can be made before the Registrar because it's the Registrar of Marriages as well. The Registrar General doubles as Registrar of Marriages in the Gambia. With that little clarification, I believe majority of the views are this amendment can go through, and we urge you to support it. It's not controversial that much. I appreciate the concern for member for Serekunda. Whatever you want to do with any document that touches on a particular sector of society, even if it is not religious, it's important the views of that sector is captured as a group. And member for Banjul North, who is a member of the committee that we are deliberating on this at that level, acknowledged that consultations were done, but the group as a group right was not had. We are amenable to that. We don't expect any adversary, but we are amenable to it. So probably when the bill goes to the next stage, we are not averse to the views of the group as a group to be had. Even though individual members of that group have no opposition. But yes, there are individual rights, there are group rights, and in this case, we want to hear what is the response of the group to this proposal. I'm not too sure whether during the consultation stage, when the bill was conceived, they were consulted, but notwithstanding, I think we are on the same understanding that the consultation at preparatory stage does not necessarily, remove your level of consultation. At your level, you are also equally entitled to consult, probably to verify our report that we have consulted them. So you need to satisfy yourself, and we are not averse to that. On those terms, Honorable Speaker, we wish to move this motion for this bill to be read the second time. Thank you very much.
Observation, member for Serekunda?
Yes, it's just something that I would want the Honorable Minister to review and then help the members to come to conclusion with this issue of the presidency, because it will keep on being asked in the consultation process. And what I remembered, Honorable Speaker, is that under the 1970 Constitution, it was provided that any prerogative that was the prerogative of Her Majesty will become a prerogative of the President when the Constitution comes into force. So what I'm not sure whether it was not the prerogative of Her Majesty to solemnize such marriages, and this was simply transferred by the order that was already put in the Constitution, as a power given to the President. But I just want to bring that to the notice of the Attorney General for further review, and then inform the National Assembly what we can use to explain. And then we may come up with amendments later on such issues. Thank you.
We will take note of it. We will look at it closely. At this stage, that much we can say is thank you for calling our attention to it. It's a very old legislation, and we need to see whether the context is applicable. If definitely not, we will come back on this. Thank you very much.
Honorable Member for Banjul.
Okay. No. Thank you very much, Honorable Speaker. Honorable Minister, I just did not want to get to what they had agreed, but there were suggestions that we just transfer it to the Registrar of Marriages, rather than the President, Registrar of Marriages. But of course, we have to consult with the groups, the Christian denomination. Thank you.
That arrangement is already in the law, but okay, I agree to realize that suggestion, we probably need to come up with another small amendment where we will delete wherever we have president and replace it with registrar. We will look into that as I promised. Thank you very much.
Thank you, Honorable Minister. Honorable members, it has been moved and seconded that the bill entitled to the Christian Marriage Amendment Bill 2020 be read second time. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Thank you.
Christian Marriages Amendment Bill 2020 deemed to be read the second time.
Honorable members, in accordance with Clause 68(1) in bracket of the Standing Order, the Christian Marriage Amendment Bill 2020 is hereby referred to the Assembly Business Committee for committal to either the committee or the Committee of the Whole House. Thank you. Clerk, you may proceed.
Bill, second reading of the Married Women's Property Amendment Bill 2020.
Honorable members will recall that the first reading of Married Women Property Amendment Bill 2020 was done on Monday, the 22nd June 2020. Today is the appointed date for the second reading in accordance with Standing Order 66(2) in bracket. Therefore, in pursuance to Clause 67 of the Standing Order, I now invite the Honorable Attorney General and Minister of Justice to move a motion for the second reading of the bill entitled to Married Women Property Amendment Bill 2020. Honorable Minister.
Thank you very much, Honorable Speaker. Honorable Speaker, I wish to move that the bill entitled Married Women's Property Amendment Bill 2020 be read the second time. Honorable Speaker, in addition to the general object of the exercise that we are doing, that is to review existing legislations with the view to removing all provisions that are either discriminatory or inconsistent with our international standing from our laws. This particular piece of bill, equally I believe, subject to what the members, how the members will view it, is non-controversial. It only seeks to remove a particular phrase from the entire Married Women's Property Act. The Married Women's Property Act is also equally one of the colonial laws, as somebody put it. It's an old one of 1885. It talks about property rights of married women, but then in turn it has some provisions that are out of date, as we could call it, are no longer used in and are frowned upon in women's rights discourses. That is the word feme sole, F-E-M-E-S-O-L-E. It means a single woman, particularly someone who was divorced. We believe the marital status, whether a single woman or otherwise, has no bearing on the right of a woman to own property. So the repeated bringing of that throughout the Act, for example, I give examples of various kinds, for instance, where you have You say property of a woman married after this act to be held by her, and then you say as a fame soul. You don't, or you say property acquired after by a woman married before the act to be held by her as a fame soul. So it occurs in different parts of the act. Another provision, it says, I'll just read towards the end, proceedings for the protection and security of her own separate property, as if such property belonged to her, as a fame soul. So we say as if solely belonged to her, simple. The issue of fame soul being repeated throughout the legislation is a bit awkward, but we can understand at the time, this is 1885. Now these things, these kind of phrases are frowned upon in women's rights discourses. So we propose to remove the phrase wherever it occurs. The act has been carefully looked at. We discovered that a mere deletion will leave everything else intact. So we just propose the removal of the phrases as fame soul or as if she were a fame soul. These are the two expressions that are contained in the act, and wherever they occur, we seek your approval to have them deleted, and then the rest of the act remains intact. With that explanation, we beg to move on those terms and seek your approval. Thank you.
Thank you. Madam Speaker, thank you for giving me the floor. I rise to contribute my quota in this important bill before us. Honorable Speaker, the Married Women's Property Amendment Bill 2020 is an important piece of legislation.
Honorable Speaker, I want to observe. It's not yet seconded.
Thank you. I rise to second. And also contribute my quota. You are right. Thank you very much. Honorable Speaker, the Married Women's Property Amendment Bill 2020 is an important piece of legislation before us. Honorable Speaker, this piece of legislation is non-controversial. Honorable Speaker, the bill is out to empower our women folk. Honorable Speaker, for far too long, our women have been marginalized. And if you look at this bill, it is out to empower our women in terms of possessing properties. Men hardly have problem when it comes to possession of property. But the women, they experience a lot of difficulties when it comes to possessing property. And this bill has come to nip that practice in the bud. Honorable Speaker, it is important to understand that this piece of legislation has been in existence for quite a long time. And as a result, some of the provisions are no longer fashionable in our this day and time. And therefore, without much ado, I want to throw my weight behind this important bill, and equally thank the Minister for having the foresight to bring this bill before us. Thank you very much.
Thank you, Honorable Member. In accordance with Clause 67(1) of our standing order, I will now open the floor for any honorable member to debate on the general principles, merit and the principle of the bill. Any honorable member who wishes to take part in the debate may do so by raising your constituency tab. Who is the next on the list?
Chairperson rightly stated, it was referred to us as the Health Committee, but as he said, this was what we really saw. And let me talk about these principles and merits. I think gone are those days when women have their plots or build their compound with a partner, then after, when there is a problem, because really, if it is healthy, it is healthy. If it is amicable, it is amicable. If it is mutual, it's mutual. But sometimes, sorry to say, but men just want to fool us. And this is the right time that we say no to it, because we build our compound together, or sometimes the husband will not have the means to be able to build the compound, and then God just come up with some things for the woman, and then they built it. And then I am full to put your name on the plot, on the compound, after you know that it does not belong to you. So I'm not saying no to other wives to come in, but let them come in with mutual understanding, and we be together. But if the man plays the other way around, that is where the problem lies. And then what I have for my fellow women is that when we have a rival in our houses, they should not be our enemies, because they are women like us. And some are saying that women are vulnerable, but with all the vulnerability, we have the children. Some of them are presidents, some are imams, some are priests, some are, you name them. And then the other thing is, men and women, we are partners. We are brothers and sisters. We are husbands and wives. You name them. So one cannot go without the other. So that being the case, when this bill comes, I know everybody will support it. Everybody in this August House will support it, because there is no controversy as far as this bill is concerned. So, Honorable Speaker, I want to thank the Honorable Minister, because he is really for women. And Honorable Minister, you should be applauded for bringing all these things that you know that are really women discriminatory. So without saying more, to keep the National Assembly with a lot of talking, I really render my support. And Honorable Speaker, I thank the Honorable Minister. Thank you.
Thank you very much, Honorable Nominated Member. Honorable Member for Kantora, the floor is yours.
Thank you very much, Honorable Speaker, for giving me the floor. I want to join the previous speakers to actually lend my support to the bill, as alluded by the Honorable Minister. This is not much controversial. However, I would really appreciate if the Minister would endeavor to provide the Parent Act for us to be guided through and see whether, these are some of the controversial points, or these are some of the replications that are there, so that it will guide us at committee stage as well, for the Parliament to be equipped with the Parent Act. That will really help us in terms of comparing the proposals with the Parent Acts. Without much ado, I just want to lend my support, and thank you so much for bringing it here.
Thank you, Honorable Member. Honorable Member for Woolly West.
Thank you, Honorable. Really, I was not going to talk at all, because these are so simple and you call them uncontroversial. For me, they are terribly controversial. Why do you call them they are not controversial? A law that was made in 1885 for English people, for England. And it was imposed on us. And you say it is not controversial. This law was made at a time when the woman was nothing in that society. Woman was a thing. That's why they say femme sole. And you say that's not controversial. A law that considers human being not anything. And you say that's not controversial. And it's imposed on you. And you freed yourself from these people 50 years ago. And yet you still have this. And you say it's not controversial. Who are we? Who are we? A law that was made in 1885 for a society that was not yours. And you are not even you are not in their thought at all. You became part because they conquered you and they imposed on you. And you free yourself, you still continue to use that law. You say it is not controversial. For me, it is controversial. It was only in 1936 that the English people considered a woman fit to go to university. 1936 was the first time ever a woman went to Newnham College was created for them in Cambridge University. That was the time they went to university. I'm wondering, Honorable Speaker, why our judiciary has taken so long to look at these legislation. The other one is 1862, 1935, or 38. And then we freed ourselves, we were independent people, but laws on our necks, which still made us slaves. And we are happy with them, and we say they are not controversial. I think this is a piece, if you go into this law, I'm sure you will still find obnoxious provisions there. So why can't you bring the whole of that legislation, this act, whole of it, review it and bring it to us instead of these piecemeal amendments? This law needs to be washed clean. Not this is not enough. I'm 100% sure that there are still obnoxious provisions in that law. It's not possible that 1885, a law made for women in 1885, almost the totality of it is obnoxious. And you are just seeing this as necessary for amendment. Honorable, I give you that challenge. I think it is better you look at this totality of this legislation to be brought here for cleaning up. Honorable Speaker, there is nobody here who will oppose these amendments. Nobody. Because they are so obnoxious that you don't even want to talk about them. Thank you.
Thank you, Honorable Member for Woodley West. Honorable Member for Serakunda, floor is yours.
Thank you very much, Honorable Speaker. The objects as stipulated in the bill need not be referred to. We are clear that a consultant went through all these documents as a part of a review of the Women's Act and see what could be done to bring all the laws into conformity with what is standards in the world for eradicating discrimination against women. The emphasis is the discrimination. Honorable Speaker, Section 28 of the Constitution says that women shall be accorded full and equal dignity of person with men. Women shall have the right to equal treatment with men, including equal opportunities in political, economic, and the social domain. What is before us is stigma. To stigmatize a human being is to discriminate a human being. There are single men, and we do not see equivalent of mem soul or men soul or whatever soul that will be ascribed to men. So why to women? So since the language is discriminatory, the bill seeks to change that language by expunging it from the Act. And in that regard, it does meet my support. Notwithstanding, I would concur with the member for Woodley West that this is just the beginning of the exercise. We may have to do deep-rooted review of all these legislations in order to expunge from them all those provisions that cannot be reasonably justified in the democratic society that we seek to build. A democratic society which must assert the sovereign equality of all human beings, irrespective of their ethno-linguistic origins, their color, their gender, their religion. That is really the fundamental objective. Thank you.
Thank you, Honorable Member. Honorable Member for Brikama North.
Thank you very much, Mr. Speaker. The amendment of the Married Women's Property Act 1885, again, I would say it's a welcome move, since it is looking into a law that is a colonial law, and if looked into, it will fine-tune it with the current happenings. This is exactly what the amendment seeks to address. The phrases appear very simple in context, but sound discriminatory before the law. And that is what the amendment is trying to address. So that cannot be a simple matter as it is in the text. Anything that is discriminatory against the women folks is not the language of the day, and therefore it is a welcoming move and a good move for that matter for the law to speak the language of the day. As earlier on been expressed by the other speakers, we believe this and many more are in this colonial law that should be looked into. And in that spirit, we are calling on the Justice Minister to do more effort in order to address that concern, so that the laws that appears to be outdated can be fine-tuned to dance with the current happenings. Thank you.
Thank you, Honorable Member. Honorable Member for Woodley East.
Okay, thank you very much, Honorable Speaker. Honorable Speaker, I think this bill intends to provide the same rights to women who are married as it does to unmarried women. I think there is a discrimination between not only men and women, but also between married women and unmarried women. I think it came at a time when in England, married women were considered to be one and the same with the husband. And so therefore the responsibility of taking care of their whatever income, wealth, has been the responsibility of the man. But then at the time, it looks like married women, unmarried women were given the privilege to keep their wealth or manage their own responsibility. Honorable Speaker, I think our situation is a little bit different, where it is not just, a man married to one person, but we live in a polygamous society, and one man will have 2, 3, 4 wives. And so therefore, managing those finances in that situation will be very difficult for some women. So all I want to say, Honorable Speaker, is that a culture is developing. I know that this culture of reducing a woman to almost nothing was not our culture. And our culture, both men and women, were liable for the upkeep of the children. And so, since women are earning, they are working, they are investing, and they also inherit. I believe this law, in principle, should be maintained to ensure that they build their independence. They manage their own finances and become independent. Honorable Speaker, I'm also concerned in our culture now something is developing, which is saying, you know, the traditional, I don't know where that comes from, the responsibility of the woman is the man. And a negative thinking is developing there for some women who feel that, well, even though they are working, their finances should not be, they should not be liable to the upkeep of the children. It's all the man's responsibility, which we must nip in the bud. The responsibility of the family, the children, should be the responsibility of the man and his wife. Because if we want to continue with this law, among this, to say that it is the man who is going to keep the finances of all these women, when the women, all of them have children on their own, that is not going to work in this society. Honorable Speaker, I think this debate is very significant since we are experiencing a lot of divorce. It's not like before. And where there is divorce, there is always a dispute regarding what belongs to who is entitled to what, the share of the property, like I said before, the furniture, etc. So women, if they are allowed to control their own finances, and even before divorce or death, it is clear what belongs to what, except the rest that can be decided by issues of inheritance. I think that will really reduce the load on the courts. Apart from that, Honorable Speaker, the word femsoul looks like the meaning is derogatory. Not only that, but it's like the person is a war. Femsoul is war. It's a prostitute. So calling people prostitute in our laws, I think that is not appropriate, and we should remove all of them. On that note, I thank the mover. Thank you.
You may proceed.
Thank you. Bill, second reading of the Women's Amendment Bill 2020 by the Honorable Attorney General and Minister for Justice.
Thank you. Honorable members will recall that the first reading of Women Amendment Bill 2020 was done on Monday, the 22nd June 2020. Today is the appointed for the second reading in accordance with Standing Order 66-2 in bracket. Therefore, in pursuance to Clause 67 of the Standing Order, I now invite the Honorable Attorney General and Minister of Justice to move a motion for the second reading of the bill entitled to Women's Amendment Bill. Honorable Minister.
Thank you, Honorable Speaker. Honorable Speaker, I wish to move that the bill entitled Women's Amendment Bill 2020 be read the second time. In addition to the reasons and objects, this particular amendment, I must emphasize, is an actual amendment of the Women's Act itself, 2010. Other series of amendments we did were amending different legislations. But this one is an attempt to amend the Women's Act itself, 2010. And it's not single, but I think about 3 proposed amendments. Amendment to Section 15 of the Women's Act, amendment to Section 43(1), and an amendment to Section 44. Honorable Speaker, Section 15 deals with adoption on temporary special measures in favor of women. Adoption of temporal special measures with respect of women. And it is an insertion of a new subsection in that provision. So the subsection that is proposed will be the new subsection. It has subsection 1. It is going to be inserted after subsection 1, between subsection 1 and 2. And the new subsection that is proposed is entirely new. So that one is the one that is before you on the bill. So we can look at it and you can agree or disagree with it. That is the new subsection we intend to insert. So this one is an insertion. It was not there. We want to add it there. Okay? Then the second amendment is amendment of Section 43(1). Section 43(1) is amended as follows. Section 43(1) deals with separation of divorce and annulment of marriage. All right? That one too has subsection 1, 2, 3, and 4. And now it is, subsection 1, only subsection 1 is going to be replaced with what is proposed on the bill. Subsection 1, which is being replaced, reads, no, 43(1) is amended as follows. So we are inserting a new subsection after subsection 5, as subsection 5 immediately after subsection 4. So that's also an insertion. It's a new subsection that we are putting in. Okay? Then the third proposed amendment is amendment of Section 44. Section 44 deals with widows' rights. That one is a straightforward one. We are adding a paragraph, additional paragraph D, under subsection 1. Subsection 1 is A, B, C, widows' rights. So we are adding a D, and that D reads, a widow shall not be compelled, for whatever reason, to marry a relative of her late husband. Yes. The word here, I think we need to, the word here, the catchword is compelled. Compelled. The law is not saying a widow cannot marry the relative of the late husband. No, no, no. We say cannot be compelled. And I think that is common sense. Should not be forced. Right? So that is the catchword. So these are the 3 proposed amendments. I will leave it for the debate. Probably when the issues come up, then I can come and respond. I don't want to preempt the debate. Honorable Speaker, we beg to move on those terms.